Good day, now let's talk about Bill of Rights. Now, let's start.
Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws.
No one can be deprived of life, liberty, or property without due process of law. In other words, the government must follow certain legal procedures before deciding on a penalty. It can't jail a person because it suspects that the person committed a crime. It must prove the accusation by following certain rules and methods.
Section 2. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized.
Section 2 protects citizens from improper searches of their bodies, possessions, or homes. It requires that a detailed warrant be issued by a judge listing what can be searched. There has to be a good reason for the search. For example, suppose the police knew that someone in your school was selling drugs. The Constitution does not let them search the home of every student. In fact, they could not search the homes of even one or two without a court order.
Section 3. 1. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding.
The right to privacy is concisely defined as the right to be left alone. The right to privacy of communication and correspondence allows persons to correspond and communicate with each other without the state having a right to pry into such correspondence and communication.
Section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances.
Freedom of speech enables people to state their opinions openly to try to convince others to change their minds. This freedom entitles citizens to say what they think, provided they do not intentionally hurt someone else's reputation by making false accusations. Neither may they make irresponsible statements deliberately harmful to others.
Section 5. No law shall be made respecting an establishment of religion, or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship, without discrimination or preference, shall forever be allowed. No religious test shall be required for the exercise of civil or political rights.
Freedom of religion means that the government may not force you to accept one set of religious beliefs, nor may it interfere with the way you worship.
Section 6. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by law.
Liberty of abode and the right to travel are constitutionally guaranteed rights in many countries where liberty of abode means that a person has a right to live wherever they wish, and the right to travel means that a person has a right to travel wherever they wish.
Section 7. The right of the people to information on matters of public concern shall be recognized. Access to official records, and to documents, and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen, subject to such limitations as may be provided by law.
Freedom of information is an extension of freedom of speech, a fundamental human right recognized in international law, which is today understood more generally as freedom of expression in any medium, be it orally, in writing, print, through the internet or through art forms.
Section 8. The right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged.
This very simply means that as a citizen you have the right to form or join a union, association of workers, or society of a particular discipline in the work field. You are able to meet with like-minded people and you cannot be denied that right.
Section 9. Private property shall not be taken for public use without just compensation.
The government's right to take this property is called eminent domain. Suppose the state wanted to build a highway which would run right through your residence. It would have to pay the owners a reasonable price for the property. The government could force you to move, but at least it would have to provide you with the money to relocate.
Section 10. No law impairing the obligation of contracts shall be passed.
This means that a law cannot be made that would stop a contract from being enforced. If someone has a contract telling them to do something, they cannot get out of it, they have to do what the contract says they have to do.
Section 11. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty.
All individuals should be given the right to access to the courts, and members of the courts should treat their people equally, whether they are poor or they are rich. They should give adequate legal assistance for those persons who are really seeking for justice. They should not give any reason for them not to help those who are in need of justice. Instead, they should help because they have the power to help their people, and most of all they should give them the freedom to access to the courts.
Section 12. 1. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. 2. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 4. The law shall provide for penal and civil sanctions for violations of this section, as well as compensation to and rehabilitation of victims of torture or similar practices, and their families.
This can be summarized into 5 main points. First, regulation of evidence collection. Second, protection from self-incrimination. Third, right to counsel. Fourth, prohibition of torture. Fifth, protection of victims' rights.
Section 13. All persons, except those charged with offences punishable by reclusion perpetua when evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties, or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required.
This section protects people from having to pay unreasonably high bail in order to be released from prison before they go to trial. Bail is money given to pledge that a person accused of a crime will appear for trial. This also protects people from unreasonably high fines. Finally, it outlaws cruel and unusual punishment. This requirement guarantees against self-incrimination and protects citizens from the use of torture.
Section 14. 1. No person shall be held to answer for a criminal offense without due process of law. 2. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable.
This protects the rights of anyone accused of a crime. It assumes that everyone is innocent until proven guilty. It can't jail a person because it suspects that the person committed a crime.
Section 15. The privilege of the writ of habeas corpus shall not be suspended except in cases of invasion or rebellion when the public safety requires it.
Habeas corpus is an order of the court which commands a law enforcement office or jail that is holding someone prisoner to bring said prisoner before the court. The reason that a court would issue such an order is to ensure that someone who's been arrested, and is being held in jail, can't be held there forever, without the court determining if the person was rightly arrested, and is being rightly held. Furthermore, the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it.
Section 16. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies.
It guarantees a speedy, public trial by an impartial jury in the area where the crime was committed. The defendant must be able to question the accusers and to force favorable witnesses to testify. The accused has a right to a lawyer.
Section 17. No person shall be compelled to be a witness against himself.
This simply means that people cannot be forced to testify against themselves.
Section 18. 1. No person shall be detained solely by reason of his political beliefs and aspirations. 2. No involuntary servitude in any from shall exist except as punishment for a crime whereof the party shall have been duly convicted.
In 1, no person shall be arrested solely by reason of his political beliefs and aspirations provided that this belief resides only in his mind. Number 2, is the prohibition of slavery.
Section 19. 1. Excessive fines shall not be imposed, nor cruel, degrading or inhuman punishment inflicted. Neither shall the death penalty be imposed, unless, for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. 2. The employment of physical, psychological, or degrading punishment against any prisoner or detainee or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law.
This is a prohibition of cruel treatment and prohibition of capital punishment. When a person is accused of a crime for which the punishment could be death, this shall be reduced to reclusion perpetua.
Section 20. No person shall be imprisoned for debt or non-payment of a poll tax.
A debt, as covered by the constitutional guarantee, refers to a contractual obligation by a debtor to pay money to the creditor. If by reason of poverty or a lack of money a person cannot pay his debt, he cannot be imprisoned by reason thereof. The creditor only has himself to blame if he voluntarily agreed to lend money to someone who apparently cannot pay or whom he thought could pay but did not. Nevertheless, although the debtor cannot be imprisoned, his property may be taken or attached by the court, and then sold at public auction in payment of his debt to the creditor. A poll tax is a tax of a fixed amount imposed on individuals residing within a specified territory, whether citizens or not, without regard to their property or the occupation in which they may be engaged.
Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act.
If a person was charged with an offense and the case is terminated without his express consent, whether by conviction or acquittal, that person can never be tried once more for the same offense.
Section 22. No ex post facto law or bill of attainder shall be enacted.
It means no bill can be passed to affect something after it has already occurred. If something is legal today and you do it, a law passed tomorrow outlawing it will not affect you. Moreover, a bill of attainder is a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative for a judicial determination of guilt. And that's all about Bill of Rights. Thanks for watching.